We are live here from Houston, Texas. We are here to cover the immigration. We're going to discuss more about the today's announcement about premium processing. We're going to update you about the H4 EAD. We're going to also update about what are the consequences of the August 9th memo and also the September 11th kick-in memo with regards to the denials without the RFE. Along with me is Emily Newman. She's our business partner. She's been writing blogs about immigration. She's very famous for her blog called immigrationgirl.com. Emily?
Hello, thanks for joining us today. We have a lot to talk about and we'll be taking your questions live. So if you have a question, feel free to post it during the video and we will try to answer it. If for some reason we're not able to answer it or we run out of time or you want more information, you can always set up a consultation with any of our attorneys at Reddy & Newman PC by going to rnlawgroup.com. We also host a daily conference call where you can call in to ask your questions of an immigration attorney each day. So you can find the information for that conference call at rnlawgroup.com as well. And anytime you want updates on the latest that's going on with immigration, visit immigrationgirl.com. So big news today was on premium processing. You know, we've been talking about file in premium, do everything in premium processing. We love premium processing.
Every video, every time we said the premium processing is absolutely necessary in a lot of cases though. And boom comes the USCIS. What promulgated the USCIS to cut its own revenue and cut, as the audiences probably are already aware of it, that the premium processing has been suspended. USCIS has suspended the premium processing in the cap cases, which are already suspended until September 10th, but they're continuing suspension from September 11th. They start suspending the premium processing for the amendments. They started suspending for the transfers. Now, in some limited cases where the extension is there, only extension without any amendment, then they are allowing to do the premium processing. What happened? Why all of a sudden? We were expecting that the premium processing should be installed back on September 10th and everybody should be able to do premium processing. What happened, Emily?
Yeah, I think that we saw this happen last year, right before, I think it was in March, they suspended premium processing before the quota because they were seeing such long processing times on regular processing cases. You have extensions with the same employer have a 240-day limit on how long the person can continue working once the I-94 expires based on the pending extension. USCIS kind of tends to put those cases on the back burner because they know they have 240 days. Those get stacked up. We end up with a backlog. Processing times have gotten worse and worse. On top of that, we're telling everyone file in premium processing. So more and more cases, because regular processing is taking so long, because we had the NTA memo, because we had the unlawful presence memo, everyone is filing in premium right now, and they're just not able to keep up, is my best guess. Now, there are some conspiracy theories out there. I kind of might agree with some of them. That
I think so with Sessions, Jeff Sessions as Attorney General, and a lot of the staff from the other senator's office. I think so. I strongly believe there is a conspiracy to intentionally delay the cases because there is a Latin word is that delaying justice is denying justice, and that's what exactly they're trying to do here. But Emily, let's go to the basics of what are the consequences. How do we get away? Now, let's cover each topic separately. For the cap cases, let's cover the premium processing cap cases. Is there a premium processing starting from September 10th?
No. So unfortunately, although we knew it was suspended, we all expected it to come back on September 10th. That is no longer an option. So premium processing will continue to be unavailable through February 19th. Now
I will cover one of the things is that what about the cap gap people? They are only allowed until September 30th, and after September 30th they are not allowed to work on the cap gap. They have to stop working. can we expedite their cases because it's a cap gap in some other method, since you said the premium processing is not there?
Right. So we can't upgrade to premium processing. There is an expedite procedure, but it's very limited in who can qualify. It's completely up to the discretion of USCIS, and the more people that request the expedite, the less people actually get it because they just can't keep up.
Is stopping working if you don't adjudicate the case after stop working, is that the reason to expedite the H-1B?
No, yeah, not by itself. So there are set guidelines for that. You can find them on the USCIS website. Just look for expedite. There is an option for severe financial loss to an employer or individual. So potentially it could fall under that, but I would say 99% of the time they're not going to expedite just because you're in the cap gap and you need the approval from October 1st.
Now, Emily, we were discussing in our previous videos the STEM extension people working at third-party location. Even though USCIS updated its website, we still need to make sure that they are getting trained at the time period of the STEM extension. And if the USCIS finds that there is no training involved in it, they might deny the change of status. Now, when they deny the change of status, the August 9th memo says the person is undocumentedly present from the time they violated the status or from August 9th. We also informed our audiences that if they are out of status for 180 days, then it's going to be violation. They will have a 3-year bar for them to come back into this country. What do you think this suspension of premium processing is going to do to them?
Yeah, that's definitely a huge concern because now premium processing is not available until February 19th. That's beyond 180 days from August 9th. So we've been telling you, watch out for February 4th, 2019. That's the date to be aware of. That's because if you, in your H-1B change of status request, if you're found to not be maintaining a valid F1 status, either because of an unauthorized CPT or because the STEM OPT was not complied with, that then leads to a determination of a status violation, which now under the August 9th memo leads to a determination that you're unlawfully present from August 9th going forward. If your decision comes in after February 4th, you've unknowingly crossed 180 days and there's nothing you can do about it. You've been unlawfully present from August 9th through the decision sometime after February 4th. Now, when you exit the country to go get your H-1B visa stamp because you got the petition approved, but your change of status was denied, you're going to trigger the 3-year bar, meaning for the next 3 years, you can't get a visa to come back because you're inadmissible due to having more than 180 days of unlawful presence. So it is a huge risk for anyone to get their H-1B decision that was requesting a change of status after February 4th. So, we may still recommend to some of our clients to still convert to consular processing so that you don't get that decision, or we may recommend leaving by
the country by February 4th
and just waiting for the decision outside the U.S.
I think so. I would recommend that people to contact their lawyers because each decision you have to make it individually, whether or not you should exit the country if there is a STEM extension training involved in it. And if there is also another topic that I want to cover is, Emily, what about those day one CPTs that we have been advising that the USCIS is cramping down on those things? What about those? They fall into the same criteria. Right. They also need to be very careful in responding to the RFEs. Also, you might want to discuss with your lawyer if you want to leave the country before February 4th. Because if you stay in this country beyond 180 days starting from August 9th, which will be February 4th or so, you may trigger in the 3-year bar, as Emily has pointed out. You may want to discuss with your lawyer if you want to exit the country before February 4th, because if you do exit the country, then you're not triggering the 3-year bar. Many questions on this, Emily. Is there anything else on the student visa, OPT and CPTs on the cap
Yeah, I think those are the main issues of now that we know there's no premium processing, potentially leaving by February 4th or ensuring that you get a decision before February 4th. If you get a request for evidence, plan that it's going to take at least 60 days to get a response after you submit the response. So if you're looking at responding to an RFE in December, you may not get the decision before February 4th. So if you have the opportunity to respond earlier, that may put you in a better position.
One other thing, Emily, now let's go to the transfer of the H-1B. If that's suspended for the premium processing according to you, can they still work on the receipt notice right now, or do they have to wait for the approval notice to work on it?
Yeah, so AC 21 still allows H-1B portability, meaning that as long as you're in status at the time of filing a transfer, once the transfer is filed, you can begin working for the new employer. And you can continue working for the new employer the entire time the extension is pending, even if it's pending for 180 days, even if it's pending for 240 days. There is no 240-day rule for a transfer. So you can keep working as long as your transfer remains pending. Now the risk is if you do keep working and it is pending for a long amount of time, so long that your I-94 expires, and maybe it was a weak case, or you get an RFE and now it doesn't look good, and you ultimately get a denial after your I-94 expires because it took so long. Now you have to worry about you're unlawfully present on the date of the denial
going forward,
and the potential for the NTA memo to kick in. So we do have the NTA memo that says that on the day USCIS makes the decision, if you are unlawfully present, which you would be if your I-94 is expired, they will go forward and issue an NTA to put you into removal proceedings. Now, right now, that memo, the implementation of the memo is on hold, but it's very possible that by February 19th, when premium processing comes back, that memo may be in play. So that's another thing to be aware of. So yes, you can still transfer. Yes, you can still start work for the new employer, but you may want to be a little more particular in the company that you're transferring to, the job that you're transferring to. Now is not the time to take a risk and file a weak case and hope that you might get lucky. Now is not the time to do that.
Only one good question came from Srinivas. I don't know if the question is good or bad. Here is the question. You're telling that there's no premium processing. The statement of work says that it's only valid for 6 months. And you file the H-1B, there's no premium processing. What are you expecting in the case when the statement of work is only for 6 months?
Yeah, that's going to be tough because now we're seeing in situations where the work order is shortened, if all of the other documentation is there and submitted, rather than USCIS issuing a request for evidence for an extended work order or additional documents, they'll just approve the case for 6 months now, or to the end date of that work order, which if you filed it in premium processing, that might be okay. But now we're in the situation where your work order might expire while you're waiting for your petition to be approved. Are they going to issue an RFE? Probably, to give you the opportunity to submit another one because you did submit it at the time of filing.
My danger is they will approve the H-1B without issuing an RFE, and they will approve it. Let's say, for example, they approve the H-1B in April of 2019, and they give only H-1B approval until December of 2018.
Yeah, we
then
have
we are
that
in
happen recently.
Problem. We have had a lot of those things happen. Luckily, with premium processing, we were able to get away with those kind of things because we were able to file the extension before the expiration of the I-94. Now, 4 months down the line, they're going to approve the H-1B, which was expired before itself. So that's a big danger that I feel. Emily, with regards to the amendment, do you see any problem where the amendment is pending, and then will that cause any problem for premium processing?
Yeah, so you can't file an amendment in premium either. The downside would mainly be if you need to travel. So we generally recommend getting the amendment approved before you travel. So now that might not be possible. You might have to delay travel plans while you're waiting for that amendment.
Yeah, if you travel while the amendment is pending, they won't allow you to come back because the USCIS has not approved your petition. So if you have any travel plans, if the amendment is pending, you'll be in danger. Now, in a different scenario though, if the project has changed while the amendment is pending, that doesn't look to be a big danger with the premium processing, because you can always file the second amendment without causing any problem, because the first amendment doesn't have to be approved. Going back to the transfer case, Emily, if the company has filed with a transfer with the client A as the end client, now you file the transfer, it's taking 8 months for them to adjudicate, plus the RFE, plus the response time, and the project is not there, they move to project B.
Yeah, I think in that situation, you exit the country, withdraw your transfer, and file a new transfer for consular processing, and hope that premium processing is back by then.
Yeah, this is going to cause a lot of problem. Now, does this premium processing affect any way for the people who are filing for the extension only, Emily?
It depends. So there are different types of extensions. There is an extension with change, there's an extension without change, and then there's an amendment plus extension. The only type of case that can be filed in premium processing is an extension without change. Those specifically always go to the Nebraska Service Center, and Nebraska is still allowing the premium processing. If you're filing an extension and it's going to Vermont or California, that means either it's an amendment plus extension or an extension plus change, then you cannot file it in premium processing. It makes sense. I mean, if you think about it, they moved cases that were extension without change to Nebraska because if there's no change, it's already been adjudicated once. This kind of goes back to that deference to prior adjudications. It's a little bit easier for the Nebraska Service Center to approve an extension that's exactly the same as what they received 3 years ago. So that's why you can still file in premium processing for those cases, where if it's an extension with change or you filed an amendment with an extension, now the whole thing has to be re-adjudicated again. They're going to go to Vermont or California where they're going to take their time with it.
This is really personally touching. The question asked by Sridhar is, what's going to happen with the driving licenses? Some of the states don't issue the receipt notices. Let me tell you one thing. I had a medical emergency, and the doctor has to drive into the hospital where I was admitted. I was saved, and that doctor was an H-1B. If that guy's H-1B transfer is pending right now, probably I would have lost my life. In those situations, in states where they're not going to issue the driving licenses without the approval, I don't think so we have any solution.
Yeah, I don't think driver's license is on the list of expedite circumstances. And I believe here in Texas, they generally have not allowed people to renew their driver's license based on a receipt notice. They wait for the approval notice.
I would recommend that you contact the congressman. Please explain the situation. You guys are willing to pay the $1,225. The USCIS want to intentionally make you suffer. That's the only thing that I take in suspending the premium processing. We are not asking for any handouts. They're telling all the immigrants are taking the money from the Treasury Department. They are taking the food stamps. That's not what we're doing. We want to pay the money here, and then they don't want to take it. They want to suffer. That's the only reason that I can take. And this one.
One of the questions was about premium processing for I-140s. That is still available, so this is only impacting H-1Bs specifically.
And we're going to move on to the other topics, cover it, and probably come back to the premium processing as you know the questions are repeating, and some of these questions are really heartfully cannot even possibly answer them in a nice fashion. The way the immigrants are suffering. Any updates on the H-4 EAD, Emily?
Nothing really. So last week, the Department of Homeland Security submitted its update to the court. It was required to do as part of the request to hold the case in abeyance. So they did submit that update, again, just stating that they are planning to proceed with the new regulation to rescind the H-4 EAD. They just are delayed. They're going through all of their final review process with all the higher-ups at Department of Homeland Security. If I had to guess, I'd say they're trying to bolster their argument as to why they need to get rid of the H-4 EAD because they expect litigation.
There are a lot of the other executive orders or the regulations are getting shot down in the courts, so they are trying to be very careful in passing anything. That's the reason why time is passed. Now, those people who are in the H-4 EAD right now, I don't think so the regulations are going to come up with that way where they're going to say all H-4 EADs are invalid. It's going to be only the further extensions. They might put some limitations on it. So if you are eligible for H-4 EAD, I would recommend that you go ahead and file for the H-4 EAD. What happens to those cases where the premium processing has already been paid? What do they do about those things, Emily?
Yeah, so what we saw last year was USCIS will try to honor the premium processing. However, once they get beyond September 11th, if they choose, they could convert your case to regular processing and just send you a refund check of the premium. We did see that happen with the Nebraska Service Center last year quite often. You know, I would expect there's going to be a huge rush of filings between now and September 11th. USCIS probably is not going to be able to handle them all, so at some point they'll probably start converting them to regular processing and issuing the refunds. And there really was no rhyme or reason to which cases they did that to. I think it was kind of random.
The major questions are coming, Emily, on the cap issues. What are they going to do? Should they take the day one CPT?
Well, definitely not that. Don't dig your hole deeper. Yeah, it's tough. I mean, I definitely understand the need to work and the urge to want to stay here. But you are on a student visa, so the only way to remain beyond your 60-day grace period that's going to start on October 1st, enroll in a new program that does not involve work, change status to some other type of visa if you're eligible. Maybe you're married and your spouse has an H-1B, so you could file a change of status to H-4. Otherwise, you can exit the country and wait outside for the approval to come through. Unfortunately, not a lot of great options, but I definitely would not recommend any program that is offering you to be able to work right away. I mean, we talked in length about this in our last week's Thursday video that CPT should not be granted until you've completed 2 full semesters. So these schools that are offering it before you reach that point, you know, they are not your typical household name schools that people are familiar with. So I would be very skeptical of those schools, and I would avoid them.
This gentleman, his name is in script that I couldn't get it, but his question is that there are a lot of rumors that the H-1Bs are getting denied for the incorrect SOC codes. Can you educate what is an SOC code and why there are denials based on these SOC codes recently as compared to what it was before?
Yeah, so the SOC code is a occupation category. So whatever your job is, the Department of Labor has a list of broad categories that every job falls under. So when you are submitting your LCA, which is generally the first step in filing the H-1B, you have to select which SOC code your specific job falls under. Once you have that SOC code, that's going to determine what the prevailing wage is for your petition. It also determines which wage level should be selected. And when USCIS is looking into the H-1B petition, they are going to reference the Occupational Outlook Handbook, which has an entry for each of those SOC codes. In that, they give basic information about what that job does, what the outlook is for the occupation, and most importantly, what it takes to get that job in terms of education. So there are some entries in the Occupational Outlook Handbook for some jobs that say these jobs require a bachelor's degree in X field of study to do this job. That is the clearest example of what a specialty occupation is, which is the only job that an H-1B can be approved for. So your job has to be a specialty occupation to get an H-1B. To be a specialty occupation, your job has to be one that normally requires at least a bachelor's degree in a specific field of study to do that job. The Occupational Outlook Handbook tells us which jobs normally have that degree requirement. Now the problem is certain SOC codes, when you look up in the Occupational Outlook Handbook, the language isn't quite as clear. They say things like, many employers require a bachelor's degree, but some do not. Or everybody has a bachelor's degree in this for this job, but they're in any kind of field, and they list 20 different fields that can qualify you for that job. Those are problematic because USCIS officers see that and say, well, it doesn't look like your job requires a bachelor's degree because of what the Occupational Outlook Handbook says. Or it doesn't look like your job requires a bachelor's degree in a specific field of study because all these other fields are mentioned. So the SOC code is very important in the strength of the case, but they're not denying for choosing an SOC code. They're denying because based on the information about that SOC code, they think the job is not a specialty occupation. And those types of denials have been greatly on the rise, probably for the last year and a half now, I would say.
When you say greatly, what's the percentage of increase?
Oh gosh, there are statistics out there, and I'm horrible with remembering them. But
I think
mean,
so. It's
like,
only 10 times.
Yeah,
that's 1,000 percentage.
Yeah, complete. Yeah.
U-turn.
So it is. I mean, that is the minimum requirement to get an H-1B, is proving your job requires that specific degree in a specific field of study. And USCIS is questioning that more and more. It started with the computer programmer memo. They said, well, we don't think computer programmers all need a degree, so we're going to look at those a little bit more. Then it spread to computer systems analyst, market research analyst, financial analyst, operations research analyst, any kind of analyst job seems to be questioned now, when a year ago, 2 years ago, it was not questioned. So there are ways to, I guess, strengthen the case. One is maybe selecting a different SOC code that has stronger language, of course, assuming that it makes sense for that job. You can't pick a doctor for your SOC code if you're a nurse. You know, that you definitely can't do that. So you have to look at that SOC code, look at the Occupational Outlook Handbook, look at what wage level is being selected. The SOC code combined with wage level 1 makes it more difficult to prove specialty occupation. But then you look at the employer's history. Have they always hired people with a bachelor's degree in a specific field? If yes, you have to provide proof that that's true. Are other employers in the industry normally requiring that same degree? If yes, you've got to prove it by getting letters from your competitors or showing that other companies have posted job vacancy announcements with the same type of requirement. So there are other ways to prove a job is a specialty occupation besides just the handbook. But if the handbook, the Occupational Outlook Handbook, has poor language, it's going to make your job that much harder to win that case.
Nancy has this question. If the premium processing has been filed and now the RFP has been responded, how long it's going to take for the RFP to be adjudicated, the H-1B will be adjudicated. You still will come under the premium processing. It will be adjudicated typically in 15 days, but the way you count the 15 days, I have doubt about how people always call, it's 15 days, it's not approved. So the way you count, I would always say that if it's 20 days, that'll be the time where you can say that it'll be adjudicated. So even though they suspended the premium processing, Nancy, you will still, since you already paid the money, they will still honor it and they will do the premium processing for that.
Well, they do have the option of giving the refund, though.
They do?
Yes.
No, of course, Nancy will not take it, or any of the people.
No. The USCIS has the
Oh,
option.
USCIS has, yeah.
If they can't get to it in 15 days, they will instead refund your money and process it.
Yeah, but I wouldn't request them until it's past 25 days, until they say that they have not done it. I wouldn't request it because they may be inclined to refund the money, which I don't want them to be refunding the money.
One question from Vishwanath is a very important one. You've got your extension coming due soon. How early should you start working on that paperwork? We've been talking about filing 6 months in advance, even with premium processing. What do you do now?
Right, with the extension right now, we still, most of the extensions probably will fall where you can still come under the premium processing. So nothing much has changed with the premium processing suspension. I would still recommend it to file the extension 6 months in advance. However, if the statement of work has a shorter duration, maybe 3 months, maybe 4 months in advance, but I would like you to get the decision before your I-94 expires. Unlike all other people, right now, most probably you will fall under the premium processing. So you should go for premium processing. Get it done way before the I-94 expires, at least 1 month before your I-94 expires. You should get the adjudication done, because once you have the I-94 validity, there are a lot of options that you have. You can file another extension. You may consider, if the denial comes in, you can file another extension. You may consider moving from company A to company B. So there are a lot of options you'll get it. We recommend 6 months, but depend on the statement of work, probably get the decision at least 1 month before your I-94 expires. Please do take into consideration that they might issue an RFE. The lawyers are going to take their time to respond to the RFE. I can't blame your other lawyers taking a long time. In our law firm also, we're taking a longer time to respond to the RFE, because each RFE is very valuable. We know that if there is any mismatch, it's going to be devastating for the life of that person. So we have to take into consideration all the aspects. There are some bad denials. Sometimes when the language in the end client letter and the vendor letter don't match the denied. Sometimes when the vendor letter and the end client letter, the language is exactly similar, they're denying those things. So we have to be very careful in articulating our argument when we're responding to the RFE. And that's the reason why we want, these things will take. So when you are filing for the extension, please take into consideration the RFE and the RFE response time by the lawyer when you are going to get the decision. Now that brings to another point, Emily. What about the September 11th memo? In the September 11th, does it mean that all the H-1Bs, as you know that about 60 to 70% of the cases are getting RFEs, probably a little bit more higher, if the person is working at a third-party location. So if we don't submit any of the documents, or if they don't like any of the arguments we make, they're going to deny it without issuing an RFE starting from September 11th, or will there be a chance for us to respond to the RFE once they issue it?
Yeah, if there is required initial evidence that's missing in the filing after September 11th, they very well can deny without issuing an RFE. Now that would typically be for an H-1B, the certified LCA, some sort of employer statement regarding specialty occupation, education documents, plus an evaluation if the degree is not a U.S. degree, and a license if the job requires a license, and pay stubs and a W-2 in the event that you're filing an extension. So I think if you have those basics covered, plus I would, as much as possible, document everything else, especially in third-party placement, contracts, work orders, end client letters, all of that. File as much as you can. You should be okay in terms of this September 11th RFE memo. I think that the goal from USCIS is to cut out frivolous filings and not have to waste their time issuing RFEs and delaying other cases waiting on a response. So I think that for the most part, most attorneys are used to over-documenting their petitions right now. So I'm not as worried about the September 11th RFE memo for cases that our firm is handling.
Yeah, but most probably what we're very fearful about is the August 9th effective memo, which 180 days is becoming on or about February 4th. That's where we are very worried about all those CPT people and also the STEM extension people, where they cannot prove that the employer is training them. That's what I'm more worried about, Emily. One question I have is, I have my H1 validity until 2020. Can I, with the H-1B transfer receipt notice, can you go to Arizona and with the receipt notice, can you apply the driving license? Oops, not a good state, buddy, to go. That's the worst state to get the driving license. However, in your case though, since your H-1B is still approved until 2020, I think so you should be able to get the driving license though. Receipt notice, I would just show them the H1 approval and the receipt notice and get the driving license until the expiration of the H1B, which is 2020. You might be in a better shape, though the Arizona is not famous for it, but in your case, you probably are good in that.
So with everything going on right now, would now be a good time if someone has an extension pending and their I-94 expired? Should they file a transfer right now?
No, I wouldn't. That might not be a good idea. If the extension is pending, why don't you do premium processing and get it resolved? That might be a good option, because extensions, premium processing, they didn't stop. So that's a good indication. If you fear that the extension is going to be denied, and you get that evaluated by a lawyer and see if the chances of the denial are very high, you may consider filing a transfer of the H-1B application, or you may consider filing the consular processing. The problem here with the transfer now is that since it's going to take a long time for you to get the adjudication of the transfer, and most probably what happens is that when there is a gap in the I-94, there is an extension pending where as soon as you join the new company, most probably your old company are under obligation to withdraw the H-1B extension. The transfer is not going to come with the I-94, and that will happen approximately, I don't know, maybe 8 months or 1.5 years from now. That's a big gamble though. If you can avoid that under circumstances right now, if you can get the premium processing, I would not try to go for transfer at this point of time.
Just to reiterate on this premium processing suspension, it's only on H-1B petitions. You can still file I-140s in premium. You can file L-1s in premium. This only impacts H-1s that are not extensions with the same employer or are for cap-exempt employers such as universities, nonprofit research organizations, and the like.
Emily, with regards to the September 11th memo, I want to reiterate that only those applications which have been filed after September 11th will be considered under September 11th. So if you file an application before September 11th, they will still issue an RFE. But as Emily suggested, we're not that fearful because most of you guys might be represented with a very good law firm. So we're not doubtful that your H-1B application will be denied without issuing an RFE. Certainly, if there are no educational documents in there, no LCA in there, they may deny that application. But if you submit the basic documentation, you should be fine.
Just to give you an update on the progress of H-1B filings in the CAP this year.
Oh, that's good.
We still have a good 35% of hours that we know were selected in the lottery that have not had any action taken on them. So they still have that same update on the USCIS website that says case was received and nothing else. So that's totally normal if you're in that situation.
Should there is a service request because nothing has been received?
No, you're not able to do a service request yet based on the filing date of that type of application. So unfortunately, now that we don't have premium processing, all you can do is wait at this time. But it is normal if you still are waiting for something to happen on your H-1B that was filed in the CAP. We have a number that are in the same situation. It seems to have slowed down a little bit, the processing. From what we were seeing a month ago, we're seeing a lot fewer things come in on that.
Shekhar has this question. His H-1B is with the same end client, same vendor. The salary has changed. Can he file extension under premium processing in Nebraska Service Center? We have done it many times in Nebraska Service Center, and we haven't seen any issue at this point of time. I think so you should be fine in applying the H-1B under premium processing because it's an extension with Nebraska Service Center. I have completed my H-1B and now I want to get back to this country on F1 on a CPT. Well, for the F1 visa, you must have an intention to temporarily stay in the United States. If you have completed the H-1B, and you have gone back, that doesn't look like the U.S. consulate are very comfortable in giving an F1 visa, particularly for those universities that are giving in day one CPT. I'll be very doubtful that you would get an F1 visa under those circumstances.
Here's a question that we haven't really dealt with at all on site visits for H-1Bs. So can you kind of explain why do we have site visits, what typically happens, and the main question that was asked is, can someone refuse to meet with the officer during a site visit?
Well, site visits was been there from the beginning of the H-1B. However, in 2010, they formed this called FDNS, Fraud Detection Unit. Most of these things were being outsourced to different agencies, but some of them are being conducted by the USCIS, ICE, and sometimes the retired FBI officers were being also assigned to conduct the FDNS. The USCIS and the Department of State has doubted that some of the people who are filing the H-1Bs are not actually working in the positions in which they have been filed for. They also have installed this new $500 fraud fees for every H-1B application we file. When we file a transfer application, when we file a new application, we file a fraud fees of $500. That money has been collected and it's there with the government. The government want to use that money to see if you are working at the same location in the same title and the same job description you're speaking about. Now, site visit used to be not that common from 2010 to 2016. It used to go on randomly in most of the cases. I would say that approximately every 50 cases or 30 cases we used to see one site visit. Now, starting from 2018, because in 2017, Hire American and Buy American memo changed the USCIS outlook, and they have actually concentrated, instead of going the random visit, they want to go for selective employers who are filing more H-1B cases, employers who are employing people at the third-party location. I would say that in 2018, the site visit is happening on every 10 cases or maybe every 8 cases, they go visit the site. Now, to generally answer your question with regards to can you refuse meeting with the officer or speaking with the officer on the site visit? Well, if you refuse it, they're going to certainly deny the H-1B. I mean, I have no doubt they're going to deny. If you say that I refuse to meet with the officer, they will deny the application. I would recommend that if you have some doubt, you may want to contact your lawyer to evaluate why you don't want to meet with the USCIS officer or the FDNS officer. I don't think so you have any right refusing to meet with the officer. If you do, your H-1B will be denied. Any doubts in that, Emily?
No, I would agree with that. A question on the cap gap. So if someone's still waiting for their H-1B to be processed and it's coming up to October 1st, if they exit the country, do they have an option of working for their same employer while they're in their home country? And are they still considered in status? What does that do?
Good question. If you are on a cap gap and you want to exit outside the country, you want to go to your home country. When you go to your home country, you're subject to your home country rules and regulations. According to the home country, you are allowed to work in your home country. Obviously, no problem with that. That's whatever country you belong to, you go to your home country, you're allowed to work. And you don't need any work permit. You don't need Redeem and PC to represent you in working in your home country. At this point of time, the governments are not recognizing cyberspace as a space where you're working in. So if you're going back to your home country and you're logging into US and you're working in US hours and you're working on the computers of the US, you are not under the US laws as far as the immigration is concerned. There are many other contracts and other things you may want to check it, but as far as the US immigration is concerned, you are working in your home country, you are not subject to jurisdiction. In that case where you're working outside the country, your H-1B will still be adjudicated. However, it will come without the I-94 because USCIS does not have the authority to issue an I-94 for the people who are outside the country. Then what you do is that you approach the consulate, you get the visa, you come into this country, and the CBP will give an I-94 for you when you come into this country, and you can work. Yes, if that option is there, you are in cap gap, I would take that option.
We talked a little bit about specialty occupation with the H-1B, and one of the questions raised is, should you or do you have to get a professor's opinion letter or an expert opinion letter to respond to that type of request for evidence? We do get them in a lot of our cases. Really just depends on the strength of the case. Some of them can be expensive, so it depends a lot of times on what the employer is willing to pay to get that letter. So is it required in every case? No, but can it be helpful in some cases? Yes.
As being an immigration client and later becoming an immigration lawyer, I've gone through the process of the adjustment of status and the H-4 and all those things. If your lawyer is recommending you to go for the professor evaluation, go for it. Don't even question whether you should go for it because you don't want to risk your status under any circumstances. I have this good question from Naga Emily. This person filed a H-1B with an end client A, and his H-1B is still pending. Now he moved to client B, and after he moved to client B, he got an RFE. What can he do? Well, it's in different location.
Yeah, I think it depends on the underlying H-1B approval. So you mentioned it was an extension. So if you're
I'm sorry, I mistake. I said the H-1B was filed under the quota.
Oh.
And the RFE has been issued. Is in a different end client right now.
I think withdrawal may be the best option there.
Yeah. There are some scenarios where some lawyers have done the amendment of the H-1B by filing an LCA for the second location. Whether it's been accidentally, their amendments were been approved and their original H-1Bs were denied. But the problem is that they came later on and revoked those H-1Bs that were being wrongly approved, thus by proving that guy got out of status. So I would not even try filing an amendment or doing anything with that case where you have moved from client A to client B in a quota case. Now in the same scenario, if it's a transfer situation, what do you do, Emily?
Yeah, with a transfer, I think then it depends on the underlying petition validity from the previous employer. I might refile the transfer and withdraw the first one, or potentially send the person outside the U.S. and file for consular processing. and have them come back with the new approval notice, especially if they have a valid visa stamp, where you don't have to get a new visa stamp in that situation.
In the same situation where the person has moved from client A to client B, what about in the amendment case? What do you do? The amendment is RFA has been issued, the person has moved to another job. What do you do?
So you have a valid approval, you've already filed an amendment to work for one location, now you're moving to a different one. I say you file the second amendment, and a lot of times I've withdrawn the first amendment because it's no longer needed.
Raghavendra has this question. I'm applying for extension plus amendment. Can I push the application for premium processing before September 11th? If it's an amendment, no. You cannot file. You cannot file it. If now that brings
before September 11th, you can.
I'm sorry, what?
Before September. Did you say before or after September?
Before
11th?
September 11th.
Yeah, before September 11th, you can, right?
I thought it's effective today.
No, September 11th. You can file up to September 11th.
Oh, sorry. Yeah. So if in the case of extension plus amendment, he can file the extension. He can file it before September 11th in premium processing.
Right. Now, they might later decide to convert it to regular processing against your wishes and send you a refund. But as of now, you can file it if you can get it to USCIS before September 11th. I think that about wraps it up for today. Again, if we didn't get to your question, or if you'd like more detail, you can always set up a consultation with any of our attorneys by going to rnlawgroup.com. You can always post questions on immigrationgirl.com and subscribe there to get the latest updates. And thank you for joining today.
Thank you guys for coming, Johnny.